right, Rebecca, you heard the announcement. Recording is in progress, so we are live. How are you?
I'm good. How are you?
I'm doing well as myself. It's been a while since you've been on, and as we were just chatting before I hit record, there's a lot of chaos out there. So we have a lot to talk about, of which I'm going to give you plenty of time to do. So first of all, thank you for doing this. Second of all, thank you for everybody tuning in. Welcome to Did You Know That? ? The channel where I get to talk to interesting people about interesting and sometimes annoying topics. And this conversation will be both. I'm just forewarning you. Thank you again. If you are a returning visitor, and if you're new to the channel, there is a subscribe button somewhere below me or below Rebecca. Make sure you hit that with the bell so you'll be notified when new content becomes available. So my name is Sean O'Rourke, if you weren't aware of that. When I am not talking to interesting people, I'm a cyber liability consultant for an insurance brokerage firm headquartered in New York City. And Rebecca, now you get to tell the fine folks who you are and what you do.
Well, thank you for having me again, Sean. It is always a pleasure to speak with you. My name is Rebecca Rakoski. I am the co-founder and managing partner at XPAN Law Partners, and we are a boutique cybersecurity and data privacy law firm focusing on the intersection of business law and technology. So,
and there's been actually forget the intersection. There's been a lot of head-on collisions.
I was going to say it's more like an explosion in the middle there, but
right.
You know.
Exactly, of which we are going to get to. But again, this is your second visit. The first time, obviously, we talked about cyber. We were talking about what businesses should and should not be doing when it comes to cyber, especially on the legal side. But a lot of stuff has gone on even since the last time we talked. Forget about all the trailing things that have happened over the last 2 years. And I guess the biggest one that I want to start with is kind of tech heavy. So we might have to sort of set the framework, and I'll let you do that. And the first one is basically a company. And there's been a series of companies, but it all started with this one, and it's SolarWinds. And now for those who aren't sure what SolarWinds is or doesn't live in the tech world, SolarWinds is just a tool, really, used by thousands of companies to sort of monitor their infrastructure. It does a lot. I'm not going to go into everything it does, or else we'll be here for hours. But essentially, it is widely used not only by companies directly, but almost more importantly, by outsourced technology companies that work with companies to sort of monitor and manage. So why don't you tell the folks sort of what happened in very brief details, because it can get a little bit complicated. The hack was more complicated than a lot of people know. But why don't you tell people what happened? And then we're going to talk about what's gone on legally so far as a bit of a fallout from that.
Yeah. So I will keep it high level, mostly because I am not a technician. I don't even play one on TV, but I do understand a lot about technology. And what happened with SolarWinds was there was an injection into basically into the software and into the supply chain, affecting one of SolarWinds products, which is the Orion platform.
Sure.
And Orion, like you said, Sean, allows businesses to monitor their cybersecurity basically across an enterprise. It's a dashboard, and it allows them to do a lot of things, including monitoring, and it sets off alerts and all kinds of stuff. But what happened was Russian hackers were able to put malware into the Orion platform. And so really an update. Right. And so when SolarWinds pushed out their update to all of their users, the malware got,
updated as well
with the rest of it.
Yeah.
Yes. And as a result, many organizations were impacted, both on the government side, Department of Defense, Department of Homeland Security, and on the public corporation side.
Sure.
And we see, it was it was a catastrophe. Now, of course, in the tech world, people are like, oh, SolarWinds was so long ago, right? It was like 2019. It was like, so 2019. But the reality of it is because of how slowly the law works, we're starting to see some of the legal ramifications now. We saw the fallout, whether it was, lack of confidence or stock prices and whatnot. I'm not going to get into any of that, but now we're seeing the legal ramifications of it. And of course, as you know, Sean, that's my favorite.
Well, yeah, I was about to say now here's where your real fun begins. And just to get back, what was really, so this happened long before the Russian-Ukraine conflict.
Yes.
This was basically standard operating procedure for Russian hackers. It was a very clever hack by essentially compromising the update server. They didn't even have to go after the live platform. They just compromised the update server. So it was sneaky good. And so it took SolarWinds a little while to find it. And then obviously it took their clients and their clients' clients a while to find it and clean it. And nobody knows what sort of information might have been exfiltrated. But from a legal perspective, again, to your point, you can solve the tech issue in a relatively good amount of time. But the legal issues have long tails and long lives. So where do we currently stand from the legal perspective from the SolarWinds Hack?
Yeah, so there were a series of lawsuits that came out of this. In addition to which, there were also regulatory fines that were issued, not necessarily against SolarWinds, but against companies that use SolarWinds. So, for example, in New York, a place near and dear to both of our hearts, they have a little law called the New York Department of Financial Services Cyber Reg 500. So NYDFS Cyber Reg requires organizations to basically have comprehensive security programs. They have to certify to that. And some of them did not classify SolarWinds as a critical vendor within their vendor management program, which is another piece of DFS. And so they got fined as a result of that. So you can see, like, it's not just the hack, it's the lawsuits and it's the regulatory fines. So in addition to the fines, we also see that SolarWinds was sued. One of the cases was brought in the Western District of Texas. And what makes this particular interest is because not only did they sue SolarWinds, the company, but they also sued members of their C-suite. Their CEO, their CISO, their chief information security officer. And this is really interesting because it's very difficult to have a lawsuit against the C-suite. We have a little thing called the corporate veil, and it's very difficult to pierce that corporate veil and to sue for shareholders. So what we see in the Western District of Texas was a lawsuit brought by a group of shareholders against the company and the C-suite. We've also seen cases pop up in the District of Delaware, and there's reasons why they pop up in different jurisdictions. And I'm not going to get into. I can go down a whole rabbit hole.
Yeah, I was about to
civil
say
procedure here, but the Western District of Texas one was the one that really caught my eye because of because they sued the C-suite. That was it was really kind of it's a difficult thing, and it was very an interesting way that they kind of framed the case against them.
Well, so they sued the C-suite, but not the board. So they separated the two entities there. So what was the argument that they were making? Because I can understand the company as a whole, but what's the argument that they're trying to win in order to go after the executives?
So basically what they said was SolarWinds executives misled the investors, that they were touting the security and the fantasticness, I think that's the word, but we'll go with it, of the SolarWinds platform and of their own security posture. So it wasn't just Orion, it wasn't just the SolarWinds product that they were selling, but it was their own security, right? That's what they were saying, that their own security was really good. And what they found through investigations and that tricky discovery that tends to reveal so much, they had really big security gaps, including a password that was like SolarWinds 123.
Right.
So, so that's what they were saying. They said, not only were you negligent in what you did, and in some instances, grossly negligent, but also you misled us. And that misleading part really amounts to fraud.
Okay, so that's what they're trying to claim, is that at least
Yeah.
on the C-suite side, it's a fraud. So
Right.
actually, again, you're a technologist on TV. I'm a lawyer on TV. So, but from a technology standpoint, if I'm the C-suite, I'd turn around and say, well, why aren't you suing my engineers who deal with the day-to-day and actually have to implement all this security protocols and procedures that we put in place and what have you? So why wouldn't the lawsuit include everybody? Why just the C-suite?
So it's very difficult to go against individual employees. The way it works with a corporation, and again, I don't want to go too far down this rabbit hole because there's a whole body of law that deals with this. But when you're dealing with the company, the employees are acting as the company. They have,
Okay.
in that instance, they don't have the level of authority to necessarily, effectuate large scale change, whereas
Right.
the C-suite
Sure.
would. So, so there you go. Now, if maybe an engineer was grossly negligent or they did something, they may try that. But I doubt a group of investors would go after employees.
That wouldn't
a
look,
stretch.
it wouldn't be a good look either.
No,
And
definitely not.
can you imagine if you go to get a job at SolarWinds then and said, oh yeah, but I might be sued as
No.
the janitorial guy here. No, thanks.
Yeah, right. I'll pass.
But I want people to understand why it sort of stops at the C-suite, even though
Right.
if you're in technology like I had been for 20 years, a lot of times the C-suite folks, even the chief technology officer, they're forests and they hire people to deal with the trees. And sometimes it's the trees that get neglected or get overlooked, especially as a company with such a massive footprint as SolarWinds has.
Yeah.
And so piggybacking off of that, obviously SolarWinds was one hack. Shortly after, Kaseya, which is another tool utilized by companies directly, but also outsourced IT companies that monitor and manage infrastructure, technology infrastructure, they also got hit.
Yeah.
Not as hard, and it wasn't as damaging as SolarWinds because Kaseya is really not used in governmental fields, but also they've gotten hit. So now what I've seen is that the hackers are saying, you know what, we don't have to go after the companies. Let's just go after the tools that the companies use. And from that perspective, now all of a sudden, part 500 of the DFS, you start to feel insecure saying, well, what do I got to do? If I can't trust SolarWinds or Kaseya, what the hell am I supposed to have here to meet these requirements?
I get this question a lot. People ask me, so a couple of things I just want to kind of unpack from what you just said is, one is, we've had this conversation numerous times. Why would I go after each individual company when I just need to go after one of their vendors?
Right.
And that's what SolarWinds is. That's what Kaseya is. They're a vendor. The problem with when the DFS fined these companies was not that they used SolarWinds, right? Was a highly reputable platform. Again, publicly, everything looked like they were crossing their T's and dotting their I's.
Sure.
But the problem was they mischaracterized what they were doing for the company, right? So if you're a critical vendor to a covered entity under DFS, that means you're a bank, you're a banking institution, you're some sort of lending institution, a credit bureau. I mean, that's who's covered by DFS. If you're not properly identifying SolarWinds as a critical vendor, that means there's something else going on that's something that important is getting missed. And
sure,
the laws now are saying, and we see this with the Department of Labor's cybersecurity guidelines with DFS. Every new law that we see coming out now is addressing this issue of vendor management and third-party vendors. And so you have to, it's about classifying them correctly, looking at the criticality to the organization, the sensitivity of the data that they're collecting. And it's also making sure that contractually you have the ability to audit and monitor what they're doing. And then if they are a critical vendor, that you're doing the audit, right? You can't just say, oh, hey, we can do this anytime we want, but then, but we don't do it. And it puts it puts a burden on organizations. I'm not going to lie. It's a huge burden. but one that businesses need to start understanding is it's not just a burden, it's also a blessing. Because if you can identify these issues early, you're going to prevent the problems, right? When I say to my clients all the time, my job is not to, my job as your attorney is to try to steer you away from the potholes in the road, right?
Yeah.
I'm not going to drive you into them. And
while driving 100 miles an hour.
Right, of course.
So,
well, I am, New York, New Jersey.
Sure. Yeah.
You're driving under 100. I don't know what you're now.
Yeah, exactly. State police, you did not hear that. You did not hear that. Yeah.
I always follow the speed limit and no texting while driving. PSA right there. Yeah. But yeah, I mean, I think it's really important for businesses to understand there's a notable benefit to doing this as well. It's not just a regulatory obligation.
Well, but let's play devil's advocate a little bit. Mm-hmm. Even if, let's say JP Morgan, I don't know if JP Morgan was a SolarWinds customer or what. Let's say Microsoft. Let's say Microsoft, because I know Microsoft was using it. Because that actually, the SolarWinds led to the discovery of Microsoft and the Exchange hack and whatever, but we won't get into that. But anyway, let's say
the rabbit hole just keeps getting deeper.
Yeah, exactly. So let's say you're Microsoft, you go and you audit SolarWinds. Is that an audit going to discover the weakness that was exploited that led to the hack? I mean, because you can only audit, even somebody like Microsoft can only audit so much.
Right. You know what? It's possible that you won't find it, but it's also, if you're doing it correctly, there's a good possibility you could find something incorrect. I mean, scans of systems and things like that can reveal weak passwords. So what if they had revealed the SolarWinds 123 password? I mean, there's ways to you know what I mean? I see clients with it all the time. They're like, okay, that's an unacceptable password. I don't have to know what the password is to know that anything with 123 after it's probably not a good situation, right?
Yeah,
and why are your systems not already set up to not use that, right?
Right.
Like,
that is true. That is true.
There's a lot of things that maybe would have been revealed by an audit. And I don't know, like I don't have a crystal ball, and hindsight is beautifully 2020, right? Like, so, but the goal there for my perspective is to mitigate my client's liability, to mitigate their risk. If they're doing everything humanly or technologically or legally possible, mm-hmm. Then the chances of them getting sued by their investors or being called up to the carpet with a regulatory fine is a lot less. So I can't always avoid the pothole, but I carry with me a really great, I do when I can. All right. I can when I, whatever. Yeah, I try to avoid the pothole when I can. But if I can't, because bad things happen, then I say to my clients, I need a gigantic, was it jack? I don't even know how to change it. Okay, there we go. I need a jack to change the wheel, and so we can get back moving. It's about reducing liability and giving me, as your attorney, creating that legally defensible position, so that if we do get sued or something, I have a laundry list of all the wonderful things that we have done and how dedicated we are to privacy and security. And it reduces liability and it reduces risk, and it avoids the enormous recovery by a group of plaintiffs, basically.
Right. Because as we talked about before I hit record, it's actually the hack itself, you could recover from in a reasonable amount of time. It's everything else that falls out of that event. And we keep calling it a hack, but it's a cyber incident of some mm-hmm. sort, because it's not always just a hack. But anyway, the fallout is really what does the damage. And because that fallout could take years, I mean, think about it. Equifax is still going through certain things. Target, there was just and it's one of the items, as everybody knows, I like to keep my questions here, but I know we're not getting to everything on this list today. But I mean, there was just a ruling from, I don't know which appeals court, but in the Target credit mm-hmm. card hacking case from 2013, that said Chubb had to cover it. And now Chubb's going to appeal it, I'm sure, and what have you. But I mean, that's going all the way back to basically the very first incident that captured the corporate media attention.
Yeah.
Even though it had been going on for decades, it captured the, the essence of what the media wanted to talk about at that point, which was
Yep.
now the dangers of technology.
Yeah.
And so these tails on these events are just so long, especially the legal ones, that companies, it's better to be as protected as possible to shorten that fallout.
Right. I mean, and that's really the problem. You see these things, they do go on for years. Despite the fact that our justice system is supposed to be swift, it is anything but,
Right.
and a lawsuit in and of itself can take years, 3, 4, 5 years, depending on the complexity of it. And these cases, as you well know, are complex. It's not easy. It's what happened, how did it happen, deposing people, getting the documents. I mean, there's so much there. And then there's as you said, the appeal process, right? Somebody wins, or there's, and then you see a lot of these cases settle out. A lot of these organizations will settle. But even those settlements take forever because, it takes a while for you. I can't recommend a settlement to a client until I understand, well, what's their exposure?
Right.
Well, and I won't know their exposure till we get through at least most of the discovery process. So,
and I mean, think of all the connections in SolarWinds where their potential exposure is. I mean, it's almost incalculable in some respects because you really have to know tens of millions of instances of where it's installed, and what have you. So, I mean,
we could be collecting Social Security by the time.
Yes.
The full extent of everything.
Maybe me, not you. Not you. I've got at least a decade head start on you by. So to that end, let's jump around a little bit because I do have this. I want to talk to you. As you know, my background, a part of my background was running an MSP, a managed service provider, which is basically an outsourced technology company for companies to utilize. So big companies, small companies, or what have you. A lot of MSPs use tools like SolarWinds, Kaseya, ConnectWise, and the such. Their clients got hit through no fault of the MSPs at all, but their clients got hit. So for the folks out there who are running MSPs who use SolarWinds and whose clients may have gotten hit, where does that stand from a legal perspective? I mean,
it's interesting because this is going to get heavily into contracts. What does the contract say? How is it structured? It also
it's the contract between the MSP and their end client, not the MSP and SolarWinds, correct?
It would be both. So,
well, we know SolarWinds wrote the contract to where you can't use it unless you agree to their stuff.
Right. Which, by the way, whether or not those will hold up, there have definitely been court cases out there where judges have said you can't give somebody a contract, not allow them to negotiate it, and then that's it. They're stuck with it. It's called a contract of adhesion, and courts frown upon that. And any chance that they get to get rid of that, they're going, or not get rid of it, but to equalize things a lot. They will. I mean, it's not a guarantee, but it's definitely something that happens. There's a principle called equity in the law, and they don't like unequitable bargaining positions, and that's kind of the definition of an unequitable bargaining position. Here's my contract, take it or leave it, right?
Yeah.
So that's part of it. But so it's going to be looking at how it all works, right? What is the contract between SolarWinds and the MSP? What is the contract between the MSP and the provider, and the client? And in those MSP contracts, are you letting them know, hey, we do use these tools. These tools are subject, so if there's an issue, I've read a lot of those contracts, and they're very heavy on, it's not our responsibility, it's all on you. But it is also a lot of, there's not as much transparency, and there's benefits and negatives to too much transparency, right? You don't want everyone to know, how everything works.
Yeah.
But with your clients, getting them to agree, having them understand what they're signing on for, and that. So it's multi-levels. And I will promise you that any MSP that gets sued that doesn't bring Solar, I would be shocked if they don't bring SolarWinds in as a co-defendant, because that would make sense, Right. Third party defendant, because
So,
it's all there. It wasn't the MSP, like you said.
so let me ask you about that, because I've been having, as people know, I say I'm a cyber liability consultant. That means I work a lot with cyber insurance.
Mhm.
And the last 2 years have been devastating for cyber insurance claims and what have you. So now the carriers, that pendulum always swings. So the last 10, 15 years before COVID hit, sure, you want cyber insurance, here you go, and it's going to cost you $1,000. Oh, you want $10 million in coverage? Okay, $2,000. I mean, they were basically giving it away.
Yeah.
Now, all of a sudden, I can't, even with a crowbar and a blowtorch, I'm having a tough time getting cyber insurance quotes out of carriers. And one of those industries to where I'm really having difficulty are MSPs from this perspective. So what I've started hearing from all my former colleagues is that they are now basically, I won't say issuing ultimatums, they're giving their clients a document that says, yes, I agree, I'm going to get cyber insurance, or no, I am not getting cyber insurance. And they want them to sign off on it. Because what they're realizing is when I left IT and came and worked in cyber insurance, getting the end user to have cyber insurance is vitally important for two reasons. One, it protects the end user should something happens, but it also protects the MSP should something like SolarWinds happens, because then their client has something to fall back on besides the MSP.
Coverage. Yes, absolutely. Absolutely. Yeah.
And so are you beginning to see that more and more businesses, industries, or what have you are saying, hey, you got to have cyber insurance. I can't work with you without it.
Will tell you that is absolutely something I look at and look for in contracts. I want to see what you've got. I want to know what you have, especially because, companies like SolarWinds, like even Target, right? I mean, millions and millions and millions of dollars. There was no insurance paying for that, right? There's limitations on that. And once you hit those limits, it's the company then has to pick up. It's not like the insurance company goes, oh, we're insuring you for $5 million, and but it's going to cost us 10. No problem, we'll pay the extra $5 million. Exactly. No. It stops.
Right.
And so it's absolutely something. But again, I go back. People think I'm crazy because I love contracts so much, but at the end of the day, that's where you've won or lost your battle before you even enter the field with a contract. Okay. If you have something in your contract that says, I am requiring you to carry insurance, I cannot work with you unless you have insurance. And what kind of insurance? Not like some fly by night, we're not going to really, but like legitimate quality coverage that is sufficient to cover your data in the event of a problem. That's what we look for. And I'm, from my perspective, it needs to be in the contract, and it's something that I recommend my clients put in their contracts.
Now, all of a sudden, the insurance provisions within a contract are 5 pages instead of half a page or a page.
It's so funny, things that people glossed over before. Now they're like, oh my goodness. It's funny because like force majeure provisions, which like nobody paid any attention to here.
Right.
Now all of a sudden they're like, COVID, wait a minute, this is kind of like an act of God. Oh my goodness, could we use the force majeure?
Right.
And so like, you never know. So it's thinking about all of this, and not, I love people who I see it all the time. They give me a contract and I'm like, this looks like somebody, like two really ugly contracts came together and had an ugly contract baby, because it doesn't, none of the words, like interchanging terms and everything. And I'm like, clearly they just cut and pasted from a bunch of different contracts that they thought looked good. But the reality of it is your contracts need to match what you're doing. And so you can't use other people's stuff. You have to craft it for your own business, because I mean, that's one of my claims is breach of contract. That's in fact the claim if it's your MSP, right? You can claim negligence. You have a contract if you're in a jurisdiction where you have to pick, and that is not that uncommon. Not every jurisdiction allows you to proceed with both a tort and a contract. I don't want to get into all this. Is going to get
Well,
very
yeah,
complicated.
exactly. But now I've got an image of you in sort of the Spartan 300 style, and on your
Okay.
shield, it says breach of contract right across it.
Yeah.
So
I won't yell "We Are Sparta," but I did love that movie.
oh, me too. But it's very funny that the way you said the contract was created when we started our IT firm and we were dirt poor. That's what we did. We copied and pasted and sort of threw it together from other contracts that we had found or what have you. Because even back then they weren't really online and available. So we just copied and pasted. And once we got them done a few years into the business, the attorney was just like you and said, you copied and pasted this, right? Because this is crap. So I said,
we can sniff it out.
Yeah, we did. Okay. So now we're gonna move on, because this is another one. And we use some adult language talking about this before we hit record. Governments, both state, federal, and agency-wise, are all trying to hop on the cyber bandwagon. I mean, since you and I talked, Laz, California had a vote and changed their CCPA, and now it's some other acronym I always forget.
CPRA, no problem. I got you.
Thank you. Thank you very much. Utah, Virginia now have privacy laws. Colorado, but all four of them are entirely different. And to a certain extent. And now, as we talked about, the SEC is proposing new regulations, and a couple other alphabet soup agencies are proposing regulations. And so I'll tell you what, I'm almost at the point where I can't keep up. And essentially, I'm just going to have a hotline to you and said, okay, I saw a new acronym. What the hell is this? Because I can't really keep up. So without diving into all of them, which are the ones that you think businesses should be on the lookout for and should start to take seriously, because it could come back and bite them pretty badly?
So all of the privacy laws that you mentioned have what I would call a jurisdictional threshold of one way, shape, or form. CPRA, CCPA has its 50 million in annual revenue, or I think it's 100,000 California residents. Virginia has something similar where it's a combination of number of residents and annual revenue. Colorado's is a little bit different. Theirs is just, there's no revenue requirement. But what I would say is, and Utah's is like kind of like the weird.
Yeah, Utah's I didn't really understand, to be perfectly honest. So,
yeah, and I think they're trying to be a little bit more business friendly in Utah. Not that the other ones are not. Privacy advocates would argue that they're not really protecting privacy rights of citizens.
Right.
I refuse to take a position one way or another on that topic. But I understand what they're saying. It's not. They're looking for the general data protection regulation out of Europe. That's what privacy advocates are like shooting for. And even that is probably not good enough for them. Yeah. But what I would say is, what I tell people when they come to me all the time is, you need to understand your data in order to understand what laws you need to comply with. So for businesses
good
out
luck
there,
with that.
I know, but for businesses out there who are concerned that these laws are starting to kind of close in on them, what I would say is contact somebody who is, who can explain to you, based on your data collection practices, these are the laws you are triggering, right? This is something I do for literally every single one of my clients. Is this is what you do? These are this law, and then so these are the laws you are triggering. Now let's make a decision. What do you want to do to comply? Which law do we want to pick? Right? Because they are different, and you can't just be like, oh, we're going to comply with all of them. It doesn't work.
Right.
So most organizations will do is take the most stringent law, comply with that, and then figure out, then we figure out where the other stuff falls out. But, it is a struggle. I'm not going to lie. Businesses do struggle with this. The worst thing they can do, the worst thing, and we've talked about this before, Sean, is stick their head in the sand and pretend like it's not happening.
Yeah.
Is go, I don't want to worry about this. No, not me, not me, not me. Because it's going to be you, because you can't control the breach. The breach will happen to you, and the breach will pull everything. Everything will come from that. That's where you get the regulators. That's where you get. So understanding the data you're collecting, I agree with you, it's very difficult to have that kind of understanding, but at least if you know, okay, these are the jurisdictions, this is the data categories I'm collecting, you can start to carve out that picture, which is what you're looking for. But it's overwhelming for businesses. I understand their frustration.
I was about to say, I was on I did an interview. I was being interviewed by an MSP, and they wanted their folks to learn about cyber insurance. And I said, cyber insurance applications are actually crap in terms of the questions that they ask. And I said, because really, you could probably boil each application down to 10 questions. And the first two being, do users have administrative rights to their PCs or their Macs or their machines in general? And two, do you know the architecture of your data? Do you know from where the data originates, who is capturing it, why you're capturing it, how you're using it, or how you're monetizing it? If you can't answer yes to those, then you better figure it out, because that is the key crux of everything we've just talked about, is the data. It's not even the systems at the moment. It's the data. It's why I don't have many apps on my phone. It's why I don't use a lot of government apps. I have a physical vaccine card. I don't use one of the apps to where you can show the vaccine card. It's just simply because the moment you start allowing the data to be captured, it's game over for the most part. But from the company's perspective, if you don't know where it originates and how you're using it, you're just asking for a disastrous situation.
It's literally a time bomb sitting. It doesn't matter. Look, you can security up the wazoo.
Right.
At the end of the day, something's going to go wrong, and something bad is going to happen. It's Murphy's law, the law of probabilities, whatever you want to call it. So if you don't understand, I like to say everything you need to know about your organization, you could have learned from Kindergarten Cop. Okay, remember Arnold Schwarzenegger?
It's not a tumor.
Right? I love that movie. But he sits there and he's trying to figure out who the dad is, and he goes, all right, we're gonna play a little game. Who is your daddy and what does he do? And where is your data and what is it doing? Right? And I will add a third question to that, is why are you collecting it? I think that was really a critical point. Like, why are you doing this?
Right.
Understanding those three pieces is going to unlock everything. Because if I have a data breach, I need to know which jurisdictions the data is coming from. I need to be, because I can't, and when I can't answer any of those questions, you have now unleashed, you have opened Pandora's box and released, what is it? I don't know what's in Pandora's box, but everything bad in the world. And before she could close the lid, hope was the last thing that comes out. That is, so, somebody did a report on it recently. I have to reread that thing.
Yeah, it's. I mean, if everybody goes back to Greek mythology and Norse mythology, it's pretty dark, and it's pretty. The human condition hasn't come very far in 3,000 years. So
no.
And I think you're right in terms of people burying their heads in the sand. But let's skip to my last question, which is not, because I still have you for about 21 minutes at least. So, but the last question I had sent you that we had talked about is, what are you telling your clients? So if I'm coming to you, is your message different if I make $500,000 a year, if I make $1 million? If I make 3 million, 5 million? I mean, because again, all the stuff that we're talking about takes effort. It takes some investment, but really it takes an inordinate amount of time. And that's very difficult for small businesses because they don't have the human resources available, or there's only 24 hours in a day. So what are you telling your clients?
Well,
now,
so first of all, I started XPAN because I looked around and I said, there are a million big law firms that are doing this. And there aren't a whole lot, there aren't really any boutique law firms that were dealing with this issue. And these smaller companies need help, and they can't afford, thousands of dollars an hour. And I got that, and that was the reason we started our firm to begin with. So my answer to your question is, it doesn't matter what size you are, right? Because at the end of the day, the hackers don't care, and the lawyers who will sue you aren't going to care. What will happen though is your business will go out of business if you are not adequately protecting yourself through the appropriate policies, through this understanding of the data that you're collecting, through obtaining cyber insurance if you're lucky enough to get you with the crowbar and this blowtorch.
Sure.
But if you're doing all these good practices, you're not going to need the crowbar and the blowtorch either, because you're going to be able to say, well, you're a good risk to an insurance company,
Sure.
a better risk,
Yep.
right?
Yep.
So I tell my clients what I don't tell them this. I don't want to say I tell my clients the same thing, but the message, I guess, is the same, right? The message is that bad things are going to happen to you, so we need to fix them. But you don't need to kill an ant with an elephant gun. Okay. So,
I love that one. That is great. Yeah.
Cybersecurity is not about like, let's just throw as much money and data privacy.
Right.
Let's throw as much money as we can at the problem and it will fix itself. You know what the really good example of that not working? SolarWinds.
Yeah.
Okay. They had tons of money that they were throwing at security and privacy, and they still had a problem, right?
Yep.
But if you tailor and you really think about the data, and you really think about what you're doing with the data, and you really think about the laws that that are being impacted by your data collection and processing practices, you can craft a program. And this is what we do. We craft a program that fits the business, right? One size is not going to fit all. It would be great if, one size fit all in every aspect of our lives, but I can't think of one aspect where that actually works, right? Yeah. And it doesn't work in security and privacy either. So having this really, I hate the expression granular, but I'm going to use it here, granular understanding of the data that you're dealing with, and then being able to create a security and privacy program around that works with the business, right? The other goal with privacy and security is that it should flow with the business. It's part of the reason why we're always talking about, go back to what I said at the beginning, this intersection of business law and technology.
Yeah.
We want to make sure that we're always thinking about what is the business and how is the law and technology affecting the business, and how can we make it work for the business and not work against the business. And so those are like the really critical things that we're always thinking. And that's, again, that's my general approach to this area with my clients is let's make something work for you, because every business is different. Every business is like a snowflake, really. Every single one is different. The way you collect your data, the way you process your data, how you share your data, all different. That's why the one size fits all doesn't work with contracts. That's why one size doesn't fit all with security and privacy programs. It's got to fit the business. Any advice you're getting that isn't incorporating that is, in my opinion, not really servicing the business itself.
Yeah.
Because it's got to work together. So that's what I tell clients.
I mean, look, that's really good, sage advice and what have you. How many of your clients listen to you?
They all listen to me. What are you talking about? I am the sage.
Hey, I set you up for that one, because I do. First of all, your energy alone, I wouldn't have the guts to say no to you. And look at that disappointing look on your face behind the glasses. Like, what did you just say? No, you did not say it.
Yeah, nobody dares to say no.
Yeah.
Look, I mean, you're always going to have, we can't have, it doesn't work this year, and that's fine. We tier it. We're like, this is the stuff you got to deal with right now. Then we move to this. Then we move to that, because again, you can't do it all at one time. It doesn't work. It doesn't
even
work
for big companies. You can't do it all at one time.
Worse for big companies. Let me tell you, the smaller ones are easier to deal with, because you only have a handful of people that you've got to pull along. Try pulling along thousands of employees. It's a lot harder. And the exposure becomes bigger, but it's also commensurate. You know, if you're a $100,000 or $1 million a year company, that $1 million means a lot to you, right? Because it's all commensurate. Whether you're 50 million, 1 million, a billion, it's all, and
Right.
it's all important to your employees too. And this trickles down and affects everybody. So it's an issue.
Well, I want to use that segue because you said not everybody's the same. However, there is something out there that is affecting everything. And I want you to put on your Karnak outfit to give me some future predicting. Log4j. So again, I won't get into all the technical details, but it is a free piece of software that tens of thousands of software installs use in some form or another. In fact, so many pieces of software use a portion of this that nobody knows how many pieces of software are potentially impacted. And so what they found was there's a massive security flaw in this free code that essentially can't be fixed or not fixed easily. So in this vein, if it's a piece of free software and you're injecting and you're putting it in and you're using it and everybody is basically using it, where's the liability?
Oh, that's a good one, Sean. Where is the liability?
Because I thought of you immediately, and this just shows you how sick my thinking is. All I could think about is, oh shit, if everybody gets hit, Rebecca's not going to sleep ever again because everybody's going to be suing everybody. Because I don't know where the liability is because it's a piece of free software that everybody is using.
So, first of all, and we've had this conversation before, I don't recommend anybody use anything free for that reason, right? Like you can't, there's no contract there, potentially no contract there. There's no agreement. There has to be some sort of, I'll never forget my contracts professor in law school that I had 150,000 years ago at this point. And I remember her standing up at the front of the classroom going, contracts are bargained for exchange. And so what are you bargaining for? Nothing.
Right.
I'm giving you nothing and you're giving me something. So there's no contract there. Could there be recklessness? Sure. Could there be negligence? Absolutely. So it could lie in either one of those, but it wouldn't lie in contract.
But I mean, if everybody's using it and every piece of software uses some form of, well, I won't say a lot of softwares use some form of free pieces of code because it's virtually impossible to write it all by yourself. Even Microsoft has to go out and find others who are doing certain things to make things work. So I've been thinking about that because there haven't been public pronouncements of anything being exploited by the security flaw. Right. But I think it's just a matter of time. And so all I can think about is it's not like it's not like Equifax who didn't put a patch in place and that's what the hackers exploited. It wasn't like SolarWinds and there were weaknesses in their security. This is just a piece of software that almost everybody uses and is so ubiquitous, but now people have found has a security flaw. Well,
Here's the thing: what they say is knowledge is power. It's also a bitch at times because see, I told you I wasn't going to curse. I was going to try to act like a lady, and you told me not to. So there I
told you not to. Half the fun of our conversations is being an adult.
So knowing that the flaw is there is going to be problematic for organizations, even if it's difficult to fix. Even if you can't fix the flaw, what are other layered security things you can put around it to prevent? You know what I mean? That's what it's really going to be. It's going to go back to the company that's using that bit of code. And it's, well, now that we know that there's a serious flaw in this, what do we do going forward? How do we fix it? And they're going to have to invest in things because, you know, if you know there's a problem and ignore it and go, oh, but everybody's doing it. That's not, there's no like everybody's doing it exception in the law. Like that, it doesn't fly, you know? And so, yeah, they're going to have to do it and they're going to have to fix it. And they're not going to be able to sue whoever created this piece of code. That's not going to happen. So it's on the business that has it as part of the software, as part of the application, whatever the case may be. They're going to have to come up with something, because my Spidey Karnak sense will tell me that if you know about it and you do nothing, that's where you have a problem every single time.
But I just don't, I mean, I've been thinking about this for months, and luckily, or maybe it's just because it hasn't been discovered yet, nobody has like I said, publicly reported an exploit through there. But considering people can't even document all the applications and systems this piece of code is in. So who knows? Okay, so
we'll see.
Yeah.
They gotta prove it too. Don't forget. It's not just about what you know, but you gotta prove it.
Well, and sometimes, sometimes hackers like to say, hey, I did this. And sometimes they may make it publicly aware. Or
sometimes they don't touch something because they're like, you know what? It's like they, for whatever reason, like for years, they didn't go at, there was like this myth that they didn't go after Apple products because like Apple was like the
cool
kid. Right. Yeah. So who knows?
But that was never really true, because there were a lot of Apple exploits. It's just that Apple didn't get hammered like Windows did and what have you. So things changed when Jobs passed away. And it's not because he was a bully. It's just that people kind of, deified him to a certain extent. So one thing I did mention, but we didn't talk about, and I obviously, since I have a legal eagle on the line, I got to go through this: the acts of war provisions in insurance policies.
I have a thing for this, Sean. Okay.
So obviously, now I think there was an article today that the cyber warfare that was expected from Russia after they invaded Ukraine is not materialized in the way a lot of people thought.
Or at least not yet that we've seen.
Well, that's the thing, is that I don't know if they're playing the long game or if they're just not playing at all. But I think it's more worrisome that there haven't been more really obvious attacks to a certain extent. But acts of war provisions, what are they? How enforceable are they? And from a cyber perspective, if you get caught up in something, let's use NotPetya, because that's the most famous one that the insurance carriers have tried to use as a defense. Where does that stand from a legal perspective and cyber? So
courts have so it's been attempted. So, all right, first of all, an act of war provision basically says, if the insurable event is as a result of an act of war, then we don't have to cover it. So a bomb gets dropped on your house is because you're at war with Canada. Pick something completely crazy.
Quite possible.
Oh, yeah. So, and your homeowner's insurance doesn't have to cover it because it's active war, right?
Sure.
It's like a really weird extreme. We'll just go with that one. So courts have in the cyber realm, and there's an active war exclusion in cybersecurity as well. Courts have pretty much universally held that the active war provision is not triggered, even if the actor is a nation state. So, when it's a hacker, they're like, like this hacker came in, they breached the system, or there was a data breach, and they're like, well, there's a difference between an individual and a nation state. North Korea, Iran, Russia, they're very aggressive hacking programs, right? Like literally state-sponsored programs.
State-sponsored programs, yep.
And that's not to say the United States is innocent in this. We obviously have our own, but
absolutely.
I'm an American. We'll just go with that. We'll just pick on the other countries for right now. So courts have pretty much held, even if it's a nation state actor, it doesn't fall into the category of an active war because there's no war. Even if it's a nation state, they're saying there's no actual war.
Physical war, right?
Physical war,
Yeah.
right. So now we have a physical war in Europe, basically. Not basically, I mean, this is what's happening. There is a war. Russia invaded Ukraine, a sovereign nation, and they are, you know, bombing and trying to take over the country. So it's a war. Whether or not, and I haven't seen a case yet where they have said, and again, it's
a little early, I think, for it.
It's a little premature.
Yeah.
But I don't know how they're going to handle that. If they do say, okay, well, there was a war, right? The Ukraine and Russia. If you're in the United States and it had nothing to do with like cyber attacks against Ukraine, well, then I think you're going to have a really hard argument. I mean, I'm sure some creative attorney will come up with a reason to make the argument. But it's still going to be hard pressed because they're going to say, well, but we were not at war with them, right? The United States.
Yeah.
The question becomes, like, obviously, countries all over Europe, including Ukraine, have, you know, created platforms and have, you know, things that we use, and, you know, so whether or not, if something goes down over there, or there's a problem with something from a like a Ukrainian application or something, I don't know. But it's going to be interesting. It's definitely an argument that was not available before. I'm sorry, it's available now. But it's something that absolutely, for lack of a better way of putting it, could be exploited and we'll wait to see what the courts have to say about it. It has not been successful really thus far.
So from again, I want to play what if with you, because it's always fun to see you start thinking.
Like 8 o'clock in the morning, right?
Yeah, no.
Better in the morning.
No. You're fantastic at all times of the day. Who are you kidding? Ask your kids; they'll tell you. So, let's say the American invasion of Iraq. Let's say, for the sake of argument, we'd be idiots to do it, but let's say we invaded Iran for whatever reason. But there was no official declaration of war from Congress. Like there wasn't in Afghanistan, there wasn't in Iraq. Is it really a war?
I love that argument. But you say you're not a lawyer. I don't know. I'm thinking we make it.
Oh, no. I just have time to sit and read and sort of ponder certain things. But I pondered specific things for you because I knew I was going to come up with the acts of war conversation.
So first of all, you'd have to, you know, I'm a big fan of the definition section.
Right. Well, it's all about contracts. So
all about contracts. Yep. So it will depend on how active war is defined.
Right.
It would not surprise me if, as a result of what's happening in Ukraine, if they try to expand that active war definition to say, even if we're not in the, you know what I mean? Because you could very easily say that, whether or not it has to be a declared war. And I actually think that has come up with some courts where it's like, well, it wasn't a official war. Okay, but you know, it was more than a military exercise. I mean, you know, for that matter, Vietnam, I think was not there. There were a period.
I mean, Korea is still officially a police action, is what they called it.
So, but I don't think anyone who fought in the Korean War would, you know, not call it a war. So and a lot of times courts will take a more practical approach. They will not say, oh, well, that's a highly technical argument and not necessarily, that wasn't really what was intended here. So, you know, it will depend, but it would not surprise me. And I haven't seen it yet, but it would not shock me if the active war definition changes as a result of what's going on in Ukraine, because it would make sense, especially when you have one actor who is so known, is notorious for their actions in cyber warfare.
Well, but to go back to one of the points that you made earlier about the equity of the contract in that regard, does that exist in insurance policies? So if they rewrite the act of war and they say anything digital, physical, what have you, that is from, I don't know, whatever the terminology is, would that still meet the equity? Or is that something that would be, hey, can we negotiate out this word? And they say, no, because you're only going to pay me $1,000 for this policy kind of deal. Does that exist in the insurance? World?
It does and it doesn't. And for the most part, they're going to go by the language of the contract, particularly when you have people who are on equal bargaining positions, like you have with businesses who are purchasing insurance, because
gotcha.
I mean, they can go out there. That it's called a declaratory judgment action, where the insurer will say, we're not covering this, and the insured goes, yeah, sure.
Right.
And they will then fight that out, and there will be a decision on that. Sometimes they will defend a case while reserving their rights to say, look, if it can't be determined now, but later down the road, if it's determined that we didn't have to defend you, you have to pay us back. And there's like a whole bunch of legal mechanisms that can go there. But for the most part, insurance has been, insurance policies are insurance policies. But courts, it depends. I hate to be a lawyer, but I don't. It really depends on the judge. It depends on the ruling. It depends on the jurisdiction. It depends on what contract law is and insurance law is in that jurisdiction. So it's hard to say like universally this is what they do, right? Because it's going to vary depending on where you are and what.
When I was in IT, and even now that I'm doing what I'm doing, the word depends is my friend, because I get to say, well, it depends.
Yeah. Well, there's especially in this area, there's no, it's not like I walk up to somebody, I shoot them, I kill them, case closed, right? There's a lot of variables that come into play in civil law.
We just talked about many of them. So
for an hour, right?
Right.
Yeah.
In the cyber. And so speaking of which, I want to be respectful of your time. But I do want to close it out. I did have a thought and now it just left me. This is the problem with recording live, is that it just left me. So I did have a thought when you were talking about redefining. You know what? I'll save it for next episode. Okay. Whatever it is, I'll keep it to an hour, because I know you got clients to save, and I've got people to talk off the ledge because there's nothing going on. But hey, Rebecca, this was fantastic. I always find something new every time I talk to you. So we'll have to make sure that we do this again. Oh, actually, I remember, before I close it out, the last few years, a number of courts, including federal appeals courts, have ruled that people who are victims or whose data have been compromised from other people do not have standing, because no actual damages have been done, even though some of the information stolen is their social security number, their health records, their addresses, driver's license. So the potential for serious damage is very real. However, courts have ruled they have not suffered actual damage, so they have no standing to sue in that. Give me your thoughts on that. And do you think that is going to remain the status quo for data breaches? So
there's actually a circuit split here, which makes lawyers super excited about this. So some courts have found they take a more stringent view of the standing doctrine, which basically says they don't have standing because they can't prove an injury in fact.
Right.
They can't prove an injury in fact because they can't say this is the data breach that caused me to have my identity theft because it's stolen, because there've been so many of them, right?
Right.
So there's two kind of schools of thought. I'm an adjunct professor. I actually teach this as part of my cyber law course. So I know, right? I'm glad you asked me a question. I know the answer to that. So the two schools of thought are very different. One takes a very stringent approach to a very, I don't want to say anti-plaintiff, more, the one more favors the plaintiff versus the defendant. Until the Supreme Court speaks on this issue, it won't be settled. It will literally be a district court by district court approach. So that's what it depends. It depends on the jurisdiction in which you are, in which you reside, or the case will be heard, which may or may not make A choice of law provision, incredibly important. Some people, they don't think much of choice of law provisions. They're like, oh, does it matter? New York, Pennsylvania, New Jersey, Delaware, California. It matters greatly depending on which circuit. Now, we sit in the Third Circuit. So, which is New York, New Jersey, and parts of New York, parts of New Jersey, parts of Delaware. Actually, all Delaware. So, you know, those courts tend to be a little bit more progressive, the Third Circuit. Whereas, you know, if you're dealing with something out of, like, I don't know, I can't even think of one of the other circuits where, like, it's less progressive off the top of my head. But so it's going to depend. So it makes the choice of law provision really important. See, once again, we're back to contracts. And, you know, I wrote an article one time called "The Devil's in the Contracts," and I'm like, you know, I hate to say it, but it's true. It really is. Like, those little details in the contract are going to make a big difference, and understanding where that circuit falls out on that issue may be really important to the business that you're representing, because you're going to have to you know, determine whether or not you are in a jurisdiction that takes a very strict approach or one that takes a more lenient approach. But it depends. With the current makeup of the Supreme Court, my guess is they're going to take a stricter approach, and that has traditionally been the approach the Supreme Court has taken on the issue of standing. But cybersecurity is a different animal. It's not something that the courts have really, it just hasn't been around in litigation that long enough for us to say, like, you know, to say the court would go one way or another on it, because it is such a unique aspect of the law.
Well, I was interested in Thomas's note in one of their recent rulings, where he said, this is not the case, but I think we should at some point revisit sort of what's called Section 230, which gives basically immunity to internet platforms for what gets posted on there. So I was interested that's the first time I've heard out of the Supreme Court anybody sort of say anything around technology, online platforms, so on and so forth. And I mean, it takes, to your point about the law taking years, Thomas may not even be on the bench when it finally happens, but I was interested that somebody up there was thinking about it.
Yeah, well, we'll see. I mean, it's unusual that I mean, justices usually say something like the legislature, the Congress should take up this issue. You know, they every once in a while will invite a case like, oh, we should. This isn't the one, but you know, it's an interesting point, and should the right fact, you know what I mean? That does happen. But yeah, we'll see. I mean, this is an area of the law that will be evolving long after we are, like I said, on Social Security. So,
yeah. I mean, long after I'm dust, unless we go back to pen and paper, this will be going on for generations.
Yes, it will. So,
well, all you tadpole law students out there, make sure that you follow Rebecca on Twitter, on LinkedIn. Where else are you?
We are on Facebook now as well.
Okay. All right. Oh, it's still on Facebook.
I don't do Instagram, you know, I don't.
Yeah, it's too hard.
I'm too old for that.
Yeah, I mean, it's like TikTok. What's a lawyer going to do on TikTok, you know, except prove that you can dance? So
yeah, not this lawyer.
Okay. Fair enough.
But we put enough on Twitter and LinkedIn. You know,
well, I'm constantly reading your stuff on LinkedIn. So yeah. So everybody give a follow, because Rebecca's fantastic. If you're interested in cyber law, all her details are down below, somewhere down here, whichever screen I'm on when the video goes up. But hey, Rebecca, like I said, this was fantastic. Thank you very much. We will do this again, because there's going to be more stuff coming down the road. So everybody stay tuned for Rebecca's next appearance, when she talks about whatever other calamity has gone on in the legal repercussions from that. But and I want to thank everybody for tuning in. You've been watching Did You Know That? ? The channel where I talk to interesting people about interesting things. And Rebecca Rakoski is definitely interesting. And the cyber law topics are, without a doubt, fascinating to a certain extent. Even if you're not interested in the law, there's so many what ifs that could go into this. We could spend here days, but we're not going to do that to you because you are a loyal viewer and you need to go and actually do something else right now. So if you've enjoyed this conversation and you're new to the channel, make sure you hit the subscribe button. Again, I'm pointing somewhere down there. And if you hit the bell, you'll get notified when new content arrives. So Rebecca, thank you very much. You take care of you and yours, and everybody out there in the ether. I will see you next time. See you.